Ladies and gentlemen, welcome to the National Constitution Center. I am Jeffrey Rosen, the president of this wonderful institution. The National Constitution Center, as some of you may know, is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. Thank you. Excellent. You can do it by heart. We've already achieved our educational mission. In fact, we can all go home now. But we can't go home, because today we are launching a thrilling initiative that I'm so glad that you are part of. We are calling this the Second Founding, and we are celebrating tonight the 150th anniversary of the 13th Amendment to the Constitution, which abolished slavery. And thanks to the generosity of David Rubenstein, who is here with us tonight, we have the privilege of displaying this rare copy of the 13th Amendment signed by Abraham Lincoln here at the Constitution Center during the 150th anniversary year. David has also generously lent us this rare copy of the Emancipation Proclamation, also signed by Abraham Lincoln, and he will talk about the relationship between these documents tonight. But this is only the beginning of a 5-year effort to commemorate the 150th anniversary of the 3 amendments passed after the Civil War. The 13th Amendment, which abolished slavery. The 14th Amendment, which guaranteed equality in civil rights. And the 15th Amendment, which extended to African Americans the right to vote. And in this sense, this Second Founding Initiative will complete the story that we tell at the National Constitution Center in our new George H.W. Bush Bill of Rights Gallery. That gallery tells the story of how the rights that were promised in the Declaration of Independence were implicit in the Constitution and were finally codified in the Bill of Rights. But as we'll learn tonight and over the next 5 years, it wasn't until the Civil War, and it took the bloodiest battle in American history, Antietam, where 17,000 men died, 23,000 died or wounded. It took Antietam and the Gettysburg Address, and finally the codification of the post-Civil War amendments to fulfill Jefferson's promise that all men are created equal. And the Second Founding Initiative has a very exciting series of bipartisan, nonpartisan partners who will sponsor a series of debates and podcasts and symposia and panels across America over the next 5 years about the Reconstruction amendments. This initiative will be part of the new Coalition of Freedom Advisory Board that we've just announced this week. The co-chairs of this board are Carolyn Fredrickson, head of the American Constitution Society, and Lee Otis, senior vice president of the Federalist Society, as well as Rick Pildes of NYU and Nicholas Rosencrantz. And this great coming together of these two groups will ensure that this is a nonpartisan initiative. We also are so honored tonight that this event is being supported by the National Endowment for the Humanities. And its visionary chairman, Bro Adams, who recently in Washington launched an initiative to convince Americans to concentrate on the common good, is here with us tonight. We're so grateful for his support, and I am so looking forward to hearing his thoughts about how this Second Founding Initiative will be part of his effort to promote civil dialogue across the United States. And finally, there's one very important partner that I need to acknowledge, and one friend in particular whose idea this is, and this entire initiative would not take place without the inspiration of Douglas Kendall, head of the Constitutional Accountability Center. The Constitutional Accountability Center is an organization in Washington devoted to promoting education about the text and history of the Constitution. And about a year ago, Doug came to me and said, the Civil War amendments are about to turn 150 over the next 5 years. We need to bring America together to have education and debate about them. And this is his vision, and this initiative is a tribute to his vision. So thanks so much, Doug, and we're so honored to be your partner. All right, this is a night of education. We'll learn a lot about the history of the 3 amendments and the relationship between them. But to start us off, I am so honored to introduce the national chair of the advisory board on the second founding, Justice Sandra Day O'Connor. Justice O'Connor, who is America's leading inspirational figure for civic education, believes, as passionately as I do, that Americans need to educate themselves about the post-Civil War amendments. She has graciously agreed to chair our National Nonpartisan Advisory Board. She is not able to be here in person tonight, but she's recorded the most inspiring message that we could possibly have hoped for, and I am thrilled to introduce you now to Justice Sandra Day O'Connor.
Good evening, and I'm sorry I wasn't able to join you in person for this exciting event, although I can't say I'm sorry to be spending this winter evening in a warmer climate. I dedicate much of my time working to teach our school children about the importance of civic knowledge, including the importance of our nation's charter, our Constitution. A few years ago, I was speaking to a large group of young people. My purse was sitting next to my chair. I'm told it was even trending on Twitter for a time. One of the students asked me what I kept in that purse. I told her that, of course, I keep the usual sorts of things there: a wallet, Kleenex tissues, a compact. I also told her that one thing I never forget to include is a copy of the Constitution. And just like I never forget my copy of the Constitution, I also never forget that we need to care and learn about the whole Constitution, not just the original articles drafted in Philadelphia and the Bill of Rights ratified soon after, but also the later amendments, including the vital amendments that we're celebrating here tonight. Amendments that ended slavery, that secured equality for every one of us, and expanded the right to vote. This is an important lesson to keep in mind tonight as we celebrate President Lincoln's constitutional legacy, and in particular, his role in the ratification of the 13th Amendment to our Constitution, as well as, and over the next 5 years, as we celebrate the 150th anniversaries of the key amendments that President Lincoln and his generation fought to secure for us, the 13th, 14th, and 15th Amendments. Tonight, we celebrate President Lincoln and his important role in the passage of the 13th Amendment, which ended slavery. He secured congressional approval of that on January 31st, 1865. He took the unusual step of signing it the very next day, calling it a king's cure for the evil of slavery. Neither the 13th Amendment nor the 14th and 15th Amendments get the kind of attention they deserve, but they contain some of the most important and inspiring passages in our Constitution. They gave our nation what President Lincoln promised at Gettysburg, a new birth of freedom. It's little wonder that scholars often refer to them as our nation's second founding. They deserve a place at the center of the American constitutional story. Over the next 5 years, I'll be working with the National Constitution Center and Constitutional Accountability Center to organize a celebration of this second founding. And this larger celebration will continue through February 2020, the anniversary of the ratification of the 15th Amendment. Indeed, I'm delighted to serve as its honorary chair. Now, thank you so much for being here tonight. Even though I couldn't join you in person, I hope you will join me over the next 5 years in helping to build a celebration that's worthy of the constitutional achievements of President Lincoln and his generation. Thank you.
Thanks so much to Justice O'Connor for her inspiring leadership, and we are so looking forward to her overseeing this wonderful initiative over the next 5 years. It's now my great honor to introduce Bro Adams, who is the chair of the National Endowment for the Humanities. He became the 10th chair of NEH this past summer. I had the great pleasure of meeting him here at the National Constitution Center a few months ago and was struck by his devotion to the humanities and his commitment to engaging all Americans in learning about our history and bringing people of very different perspectives together for civil dialogue. Since that conversation, he has launched an important initiative devoted to promoting the common good. His support for this event tonight is part of that initiative, and I'm so eager to have you meet him and hear about his project. He was the president of Colby College in Maine from 2000 until 2014. He's had an illustrious career in higher education, including stints at Stanford. He was vice president of Wesleyan University and president of Bucknell University in 1995 before becoming president of Colby in 2000. Ladies and gentlemen, please join me in welcoming one of the great champions of the humanities in America, the chairman of the National Endowment for the Humanities, Bro Adams.
Good evening. And thank you so much for being with us here tonight. I want to thank and congratulate Jeff Rosen on this extraordinary initiative and thank him as well for inviting me to be here. I'm honored in several ways to be among the distinguished people you will hear from tonight. Wonderful company, Sandra Day O'Connor in virtual space, and here physically David Rubenstein and the distinguished panelists you'll hear from in a minute. And our association, secondly, with the broader project about which Jeff briefly spoke. And the reasons we're so compelled by that project are four. This topic that we're talking about tonight, the 13th, 14th, and 15th Amendments, with the emphasis on the 13th, is in itself, of course, an enormously important historical moment in American life and history. But it also has, secondly, enormous contemporary relevance, and I know that's going to come up tonight. It is perfectly fitted to the mission of the National Endowment for the Humanities and the work that we do, and it is perfectly fitted with the initiative that I announced in January called the Common Good. Let me just touch very briefly on those points. Jeff calls, and Sandra Day O'Connor calls this very rightly, the second founding, this celebration and this moment in history. It, of course, was the monumental expansion of the meaning of the Revolution and of 1787, making equality co-equal with liberty in the way we think about our constitutional heritage. And ever since then, equality has been, of course, one of the most important touchstones of our political and social lives. The 150 years since that time, of course, those years have turned in many ways on the struggle to define the legal and political and social meaning of those critical amendments, including the amendment that followed some years later, the 19th Amendment in 1920. I use that word struggle deliberately and advisedly. Struggle in the sense, first of all, as we know, in the constitutional argument that we have in this country constantly, and the debate about the meaning of the Constitution and the implications of equality in that constitutional structure, but also struggle in a different sense and maybe more common sense form as it's played out in broad popular movements as well as in institutional political settings, which of course these amendments have done. They are, of course, enormously important in our contemporary politics. We continue to struggle with the meaning of these amendments. First of all, in the constitutional sense, we're debating it still, and I'm sure we will continue to debate it for many years. But also they inform our political debates and arguments about equality as defining elements of our time. It is undoubtedly the case that we've seen a great deal of progress since the 13th Amendment. I mentioned the 19th Amendment, and then, of course, the watershed moments in history since the Civil Rights Movement of the 1960s, for example, and the monumental legislation of that time, the Civil Rights Acts of 1964 and 1968, the Voting Rights Act of 1964, and other important things that happened in the Civil Rights movement. And then, of course, the election of Barack Obama in 2008, the first African-American president of the United States. Even as we're aware of that progress, and it has been significant, we are aware of the limits of that progress, and we became very painfully aware of the limits this last summer in Ferguson and Staten Island and Bedford-Stuyvesant. So this project that is being launched tonight is really, in every sense, living history. And it's a critically important form of civic engagement for this country at this point in time in our history. It is also perfectly fitted, as I said, with the mission of the National Endowment for the Humanities. Speaking of the 1960s, by the way, we are going to be celebrating this year our 50th anniversary. We were founded as part of that burst of legislation in the mid-60s on September 29th, 1965, when President Johnson signed the act that created the National Endowment for the Arts and the National Endowment for the Humanities. In the congressional language, in that bill that created us, there were two fundamental charges. One was, and still is, to advance and contribute to the great humanities tradition that goes in the West, of course, all the way back to the Greeks and beyond, and in other parts of the world, of course, in equally deep and great traditions. But also, and secondly, very importantly, to engage the public by connecting that tradition to the circumstances of contemporary life. Those are words that come right from our legislation. And at the very heart of that work, of connecting to the circumstances of contemporary life, has been our effort to illuminate, support discussion of the history and the foundational principles of American democracy, and to connect those principles to the way in which we live now. And that is what led me, frankly, this last January to announce a new initiative called the Common Good, the Humanities in the Public Square, the purpose of which is to bring humanists, humanities knowledge and understanding, and humanities organizations to bear upon the grand challenges that we face in contemporary American life. And the rationale for that urge to bring those traditions to bear on our circumstances is this, and it's very simple, I think. The grand challenges we face as a people now in this time are not principally technical or scientific challenges. They are challenges that bear upon our history and our culture, our ideas and our values. And it is in addressing those spheres of life that the humanities, I think, really shine. So we need them. We need their methods and we need their forms of knowledge. And no challenge could be larger or more important than continuing the public discussion and debate regarding the meaning of Lincoln's legacy and in our current circumstances. And so for us at NEH, this initiative of the National Constitution Center is a perfect embodiment of what we are trying to achieve. I'll close with a very brief anecdote about my mornings in Southeast Washington as I get up and get ready to go to work. I moved to that part of Washington, the Southeast, when I moved to Washington in July. It's my habit, because I'm a cyclist, to get up and ride my bike in the morning, and I do 3 days a week at least. And I typically go out past the waterfront, around Haynes Point, some of you might be aware of that geography, past the Jefferson Memorial, and I go and turn around the Lincoln Memorial. And it's occurred to me as I've done that every morning that we have so mythologized in some ways Lincoln and embedded him in a kind of almost unreachable realm that I think we forget about the contemporary circumstances and the contemporary meanings of his legacy for the ways that we live now. And if I am ever tempted to forget it, the other part of my morning typically involves a metro ride. I get on the Green Line at the Navy Yard. Some of you might know that station. And I ride 2 stops to L'Enfant Plaza, where I get out and I go upstairs and go to work. The train, as it arrives in the Navy Yard, is coming from Anacostia and the 8th Ward, which is just across the river. The Anacostia is a neighborhood that is 97% African American, and it is one of the poor neighborhoods, not just in Washington, but in that entire region of the country. It has a long and distinguished history, by the way. Frederick Douglass was born there. But then and now, it remains, I think, an emblem of racial segregation in our nation's capital. We have lots of different disagreements about the role of the federal government in addressing segregation and the causes of segregation in this form. But it is a material fact that we need to keep in mind as we ponder Lincoln's legacy and the 13th, 14th, and 15th Amendments. Thanks again to Jeff and the National Constitution Center. We're very proud to be involved in this partnership, and we thank you all for your engagement with us. Thank you very much.
Thank you so much, Bro, for that wonderful speech. We're so honored to be part of your Common Good initiative and so convinced, like you, that Lincoln's legacy is something that belongs to all Americans and is important to debate. It's important to debate both the historic aims that he and the framers of the Reconstruction Amendments were trying to achieve, and it's important to debate their contemporary significance. And there are good arguments on all sides of this debate, and citizens can disagree in good faith about how broadly the amendments were intended to sweep and how they should be applied today. But because the Constitution itself is a conversation, bringing all sides together for this respectful debates and civil conversations is a great contribution to national education. So thank you for your support. Ladies and gentlemen, it's now my great pleasure to introduce my friend and co-author and a great friend of the National Constitution Center, David Rubenstein. David, yes, a good round of applause at the beginning. David, as I said, has generously loaned us not only this magnificent copy of the 13th Amendment, which I hadn't seen before now, and after the show, please don't come on stage, but come and inspect it and see Lincoln's signature. And David will tell you about both the provenance of this document in riveting detail and also about its historic context, but also this rare Emancipation Proclamation. I first came to know David Rubenstein when he came to the National Constitution Center to lend us a rare copy of the Declaration of Independence. And when he came and I put on a ceremony to thank him for his loan and interview him about the Declaration, he was so effective and riveting in his ability to translate the aspiration of the Declaration for all Americans and his unique ability to connect Jefferson's goals with the goals of the framers of the Constitution, that as a result of that conversation, we co-wrote a thrilling pamphlet together, which you can find now in this beautifully produced pocket copy of the Constitution, published by the National Constitution Center, which has a pamphlet that David and I wrote about the relation between the Constitution, the Declaration, and the Bill of Rights. I gather, C-SPAN viewers, that you can even buy this absolutely irresistible document on Amazon for an extremely reasonable price. And this introduction, this pamphlet, became the basis for the script for our Bill of Rights gallery that I want everyone here to go see after the show, which displays David's copy of the Declaration of Independence with the first public printing of the Constitution and one of the 12 original copies of the Bill of Rights. But David's knowledge about the founding era is not the limits of his talents as a constitutional educator. He is one of the most gifted exponents in America about the history and purposes of the 13th Amendment. And I've seen him talk about the 13th Amendment once before. I think the first time I saw you actually was when you talked about the 13th Amendment in Aspen, Colorado. There he is off stage. But he, really, there's no one in America better prepared to tell us in riveting detail about what the framers were trying to achieve, what Lincoln was thinking when he signed this amendment, and what the significance of the 13th Amendment is on its 150th anniversary than David Rubenstein. Please join me in welcoming him now. David.
People here actually believe I can live up to that introduction. Anybody? No, there is nobody. Maybe my mother, but she's not here. The truth is, there are scholars here who know far more about it than I do. I will try to give you a layman's appetizer, and later we're going to go into more detail with people who know much more about it than I do. But some of you may be wondering, how can an individual actually own these documents, and why isn't the Emancipation Proclamation or the 13th Amendment back in the archives? Well, let me try to explain. Lincoln did sign on January 1, 1863, the Emancipation Proclamation. He signed it on a day which was very busy in the White House in those days, because the president would open the White House to anybody who wanted to come in. He would shake about 2,000 hands, and then that day he went up and signed the Emancipation Proclamation. That copy is in the National Archives, and it's open to the public or some select people to see only one day a year, January 1. It's very fragile. As a souvenir, in effect, President Lincoln was asked, would he sign additional copies to raise money for wounded Union veterans? And he did. He signed, I think, about 47 of those copies. They were to be auctioned off at about $10 a piece. Only 6 of them sold. The price was considered too high. About 26 of them remain. And one of them is here. I had previously lent it to President Obama. It was in the Oval Office for a while. And it's a copy that is interesting in that it has the text of the Emancipation Proclamation, and it has Abraham Lincoln. Abraham Lincoln signed his full name only when he was signing something significant. Generally, he would sign A. Lincoln. But obviously, for this, he signed it. And today, it's an historic document. I think one of the most historic documents in our country's history. And probably with the stroke of a pen, no document by a President of the United States has ever been more significant. The other document is the 13th Amendment. As you just heard earlier from Sandra Day O'Connor, that was approved by the Congress on January 31, 1865, and then by December of 1865, it was completely ratified by 27 states. Lincoln had no role in actually officially signing the 13th Amendment, because, as you all know, to get an amendment approved, you need 2/3 of each member, each house, 2/3 of the members of each house, and 3/4 of the states. There's no official role for the President of the United States in the amendment process, but Lincoln was so excited about it that he signed it anyway, and you'll see his signature there. The Congress passed a resolution kind of admonishing him for getting in the middle of the process. He wasn't supposed to sign it, and then he ignored that anyway. But he did sign about 15 copies of these, and this is one of, I think, 15. So why did we need an Emancipation Proclamation, and why do we need a 13th Amendment? Well, let me give you a 10-minute summary of it, and I don't think I can possibly do justice to all the facts, but I'll try to do it very quickly and give you a layman's version of it. When our country first started, we obviously had slavery. And slavery was something that we had for more than 200 plus years. In fact, we had slavery a longer period of time in our country than we haven't had slavery, because from the 1620s on to about 1865, we had slavery. We had about 600,000 slaves that were brought to our country. At the time of the Civil War, we actually had about 4 million slaves because of reproduction and so forth. 3.5 million in the states that seceded, and about 500,000 in the border states that didn't secede, but there was no doubt slaves there. Most of the northern states had eliminated slavery in the early 1800s. So when we had the Declaration of Independence, and Thomas Jefferson wrote those famous words about everybody being treated equally, many people laughed, because they said, how can you say everybody's equal when you have slavery? And in fact, that was one of the responses of the British government. They said, what do you mean everybody's equal when you have slaves? and we had probably close to 1 million slaves at that time. So Thomas Jefferson and other founding fathers recognized the inconsistency of thinking that everybody was equal, but we still had slaves, but they couldn't do anything about it. Thomas Jefferson, as a young man, wanted to do something about it, but he recognized it was not possible to really change slavery, and he kind of lived with the system. And that system grew and grew and grew, and as cotton and tobacco became more and more important, more and more slaves were needed in the South, and more slaves actually came to the United States. And in the end, slavery became a very important part of the Southern economy. When Abraham Lincoln was running for president of the United States, he was widely seen as somebody who wanted to keep slavery from being expanded to new states. And we had a compromise before about which states could have slaves and which states couldn't have slaves. And Lincoln was seen as being much tougher than the South thought he should be in keeping the expansion of slavery from going forward. Lincoln was elected. He was elected with a minority of the popular vote, but he was elected with obviously a majority of the electoral vote. It was widely viewed by many states in the South that he would eliminate slavery not just in the new states, but in the South eventually. So initially 7 states seceded. Lincoln's determination was to bring the Union back together, and he said repeatedly, my greatest goal is to bring the Union together, and I'll do what it takes. He originally was not considered an abolitionist. He was not considered a great emancipator. But he eventually concluded that the only way to win the war was to take part of the Southern war machine away, and to do that, he decided he would issue the Emancipation Proclamation. He told his vice president, and he told some of his cabinet members about it around June of 1862, and they were very surprised because he had never before said he would do anything as significant as that, but he had determined to do so. Eventually, taking the advice of one of his cabinet officers, he waited until there was a military victory so it wouldn't look like he was desperate, and there was a military victory. He decided to go ahead and issue a preliminary Emancipation Proclamation on September 22nd of 1862. And that said essentially that 100 days hence, if the Southern states hadn't agreed to come back into the Union, that those states would have slaves in those states basically would be freed. Now, he exempted certain areas, and it didn't cover that many people, and as some people like to say, the Emancipation Proclamation didn't actually emancipate anybody, because the people who were to be freed were under the control of Southern states and Southern slave owners, and they weren't freeing the slaves. But eventually, several 100,000 slaves did leave their slave owners, and eventually they came north, and about 200,000 nearly ultimately worked in the military effort on behalf of the North and became Northern soldiers fighting against the South. But the Emancipation Proclamation didn't really solve the problem. It didn't really end slavery for sure. It only said those slaves in states that have seceded from the United States, if these states don't come back, the slaves there would be freed. But it didn't actually say anything about the border states. In other words, if your state hadn't seceded and you were a slave, you weren't covered by the Emancipation Proclamation. So it was really done under the War Powers Act that the president considered he had, and therefore it wasn't clear what the legal standing was. He was always afraid that this would be overturned by the courts, and many people have criticized the Emancipation Proclamation for not having the flowing rhetoric of the Gettysburg Address, and Lincoln was afraid that the Chief Justice Taney or the Supreme Court would overturn the Emancipation Proclamation if it was very clear that he gave the reasons for it. He didn't give the reasons. It's a very legalistic document, and he basically says these areas will be having no slaves after a certain period of time. Well, the preliminary emancipation was ultimately made final on January 1 of 1863. It didn't necessarily win the war. The war machine didn't fall apart, and as we know, the war didn't really end until April of 1865. But Lincoln pursued the idea that ultimately there would be the end of slavery. As the war was coming further along, there were still many difficulties in winning the war, but many people thought you couldn't really win the war and ever really bring the country together again as long as you had slavery. And so many people in the North thought you had to end slavery, and the only way to do it was through a constitutional amendment. And that was considered very unusual because there hadn't been a constitutional amendment for 50 years. After the Bill of Rights, there had been only 2 other constitutional amendments. So for 50 years, people hadn't amended the Constitution. And why not? Because it was considered almost like the 10 Commandments. It was sacred. And as a result, people didn't want to amend it. They said the Founding Fathers had given us a certain government, and if we're going to change certain things, we should do it outside of the Constitution. We shouldn't amend this enormously important document. Ultimately, people concluded that the only way to really end slavery was through the amendment process, And so the process began to amend it. Lincoln actually didn't support it initially, or publicly he didn't support it. He basically was silent on it. The idea of having an amendment to end slavery went through the Senate in 1864, and it was passed by the Senate, but it went to the House and it failed. And so there weren't enough votes. It failed by a reasonable amount. You have to have 3/4 of the members voting for it, and it didn't get that. It failed by about, I think, 16 votes. And as a result, the constitutional amendment wasn't passed, and we went into the 1864 election. And Lincoln, in that election, really never was as ardent a supporter of the amendment as people later thought he maybe should have been, because it wasn't that free of controversy. There were many people who didn't really think we should use an amendment process. Ultimately, Lincoln decided, after he won the election, that the best way to end the war was to make it clear to the South that there was not going to be any opportunity to come together and have slavery again in a reunited country. He wanted to make it clear that if the country was going to come together again, it had to be without slaves in the South. And so he worked very hard to get the constitutional amendment passed in the House. And as you probably saw from the movie Lincoln, that's what the movie Lincoln was really about, getting it passed in the House. Lincoln had not really been involved in the legislative process all that much as a president. He usually let Congress do what they wanted to do, and he really wasn't that involved in the initial parts of the 13th Amendment being passed by the Senate, and he wasn't involved when it was really being defeated by the House before the 1864 election. But after the election, he decided he wanted to get it passed, and wanted to get it passed before the new Congress came in. In 1864, when he was reelected, there was a new Congress, and the new Congress was even more Republican and presumably even more favorable to a constitutional amendment, but he would have to wait for almost a year before the new Congress would come into effect, and he wanted to put pressure on the South right away. So he worked very hard. He didn't actually meet with that many members of Congress, but he did things he'd never done before to make it clear that he wanted this passed. Ultimately, it was passed, and ultimately, as I noted, the president signed it. It didn't solve all our problems, for sure. All it did was to say that slaves were to be free. It didn't say they had citizenship. It didn't say they had equal rights. It didn't say they had any rights. It didn't say they had the right to vote. And as we know later, the 14th Amendment and the 15th Amendment were needed to deal with those problems. But it is interesting that the 13th Amendment was considered at the time an enormous change to the Constitution, because we'd had slavery for so many years and now it had ended. But it didn't really solve the problem, for sure, until you really study the other amendments and recognize that even with the 14th and 15th Amendments, we obviously didn't solve the problems that we have had of discrimination and lack of real civil rights, and we've had to deal with that throughout our history. But I do think as you look back on history, you recognize that among the most important documents in our history, in addition to the Constitution and the Bill of Rights, are the Emancipation Proclamation, where, again, by the stroke of a pen, was the most significant thing any president probably ever did, and the 13th Amendment, which was probably the most important amendment in changing the direction of our country. Our country had a fatal flaw at the beginning. We tried to correct it through the 13th Amendment. It needed additional amendments to really give African Americans the kind of rights they deserve, but we still have many, many problems, even 100+ years after these documents were approved by Congress. So there's a long way to go, but I do think learning the history of these documents and learning how Lincoln thought about them and learning the extraordinary anguish that he had in addressing these issues. Should he support an amendment? What type of amendment should it be? How should he negotiate it? And what would be the impact of it? It was very, very clear that these issues are ones he struggled with. And anybody who studies Lincoln, and anybody who studies him carefully, will come away, I think, feeling that he's an extraordinary individual. And probably no other person would have been able to hold this country together, because he was determined to hold the country together. In the end, he did it by eliminating slavery. So I think all of us owe him a great deal of gratitude for what he did for the country, and ultimately he paid the final price. And think about this, and the final comment I'll make about it. He didn't say that in the 13th Amendment that African Americans would have the right to vote. But there was discussion about what would happen. What would it mean if the slaves were free? Would they be free to do anything? Would they have any civil rights? Would they have the rights to serve in juries, the right to vote? Would they be able to get jobs? These issues were somewhat unclear. At one point, he made a speech shortly before he died in which he said, well, perhaps blacks, African Americans who fought for the war, fought with the North in the war, and worked on behalf of the Union to win the war, perhaps they deserve the right to vote, and perhaps African Americans who were very well educated, perhaps they had the right to vote. Well, when that speech was being given, John Wilkes Booth was in the audience, and he heard it. And he resolved then that he needed to go forward with his plan to kill the president. And 4 days later, he did so. And it's a tragic ending, and Lincoln did not live to see the 13th Amendment actually ratified. That occurred in December of 1865. He obviously died in April of 1865, but it's one of his great legacies. It's one of the things that all of us owe a great deal of gratitude to him for. So let me end there and say, Jeff, I'm happy to take any questions about this if you'd like, or anything else on the subject.
Wow. Thank you, David, for an extraordinary presentation. You've told us about the provenance of these documents. You've told us about Lincoln's goal in passing the amendment and his struggles about how broadly it should apply. And you've told us about its limits and the subsequent amendments. I have many follow-ups. Let me begin by saying I know you read deeply in the 13th Amendment, but you just read or reread 2 or 3 really good books. What do you recommend to the audience to read about the 13th Amendment?
Well, there's an excellent book on the 13th Amendment written by Professor Vorenberg at Brown, and I highly recommend that. And Eric Foner has just written a very, very good book on Lincoln and slavery and the relationship between Lincoln and slavery, and that won the Pulitzer Prize. And I highly recommend that. It's a very good discussion of the 13th Amendment as well. And one of our guests later has written, I think, the ultimate book on the Emancipation Proclamation, and we'll talk about that shortly.
Wonderful. All right, well, let's read the text of the 13th Amendment, once again from this superbly produced pocket constitution with its absolutely magnificent introduction.
Is there any jewelry that comes along with this if you buy it? Or is this,
there is. Actually, you can get Benjamin Franklin's snuff box. Okay. The one that he received from the King of France and got really criticized for. Okay. We'll give you a reproduction of at a very reasonable price. So here's what the 13th Amendment says. Section 1 says, neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. And then Section 2 says, Congress shall have the power to enforce this article by appropriate legislation. I want to focus first on the language in Section 1. Slavery can't exist within the United States or any place subject to this jurisdiction. Tell us again, because it's so important, the original Emancipation Proclamation, you told us, only applied to southern areas under Union control because Lincoln was acting under his authority under Article 2 as military commander-in-chief, so he felt he didn't have power to free the slaves in the North, in states like Maryland. Is that why you needed this broader version of the 13th Amendment?
Lincoln was a person who revered the Constitution, and he considered it a sacred document. And he didn't feel, as president, he had the right to change the Constitution. The Constitution said that slavery, in effect, is okay if you want to have slavery, and the Constitution was in effect recognized slavery. Some people would say the Constitution was a pro-slavery document, others say it was an anti-slavery document, but more or less it recognized slavery. Those who say it was anti-slavery would say that eventually it was recognized it would fall away, but over many, many years. Lincoln didn't feel he had the power to eliminate slavery under the Constitution, but as commander-in-chief, he felt he could say, in effect, that he had the right to end slavery. He relied, I think, on the legal work of a scholar a lawyer from Boston, who later he made the Solicitor of the War Department, William Whiting, and that gentleman basically had a theory that slavery was something that could be ended by the war powers, in effect, of a president. So he used that, but he only was able to end slavery, in effect, in areas that were under control of the Confederacy. If an area was under control of the Union, or it was a border state not seceded from the Union, then he didn't have that war power. Now, on that language, the language of the first section you read was very simple. Where did that language come from? Well, we had something called the Northwest Ordinance, and under the Northwest Ordinance, we basically recognized certain states and created certain states: Ohio, Indiana, Wisconsin, Indiana, Minnesota, and Michigan. Language creating them actually had that language in it. And in fact, the draftsman who drafted the 13th Amendment really pretty much took that language, which actually probably came from Thomas Jefferson because he had helped write the Northwest Ordinance. So that's where the language came from. The controversial language was the second section, because it said the federal government will have the right to enforce this. Well, what does that mean? As the 13th Amendment was being debated in the Congress, people said, well, what does that mean? Will blacks be able to vote? Will they be able to have citizenship the same as whites? Will they be able to go to schools the same as whites? And it was unclear what it meant. Now, the people who wanted to pass it said, well, it doesn't really mean anything. Don't worry about it. It's just pro forma language. Those people who really wanted the federal government to get more involved said at some times, privately and then later publicly, it's really giving the federal government the authority to come in and, in effect, make sure that there could be rights to vote and civil liberties for people who were freed from slavery. But it was unclear at the time.
Fascinating. So tell me more about Section 2. As you say, the most ardent supporters of it believe that Congress had the power to ban the badges and incidents of slavery, not only slavery itself, and that can include banning private discrimination.
Yes.
How widely was that view shared?
Well, those people who wanted the 13th Amendment to be passed, in order to get it passed, they were saying, well, it doesn't mean anything because they wanted to get as many votes as possible. After it was passed, some of the same people said, well, we really meant it had more authority than maybe we said at the time, and they really thought that the federal government should be more actively involved. There was enormous racism in the Senate and the House in those days and in the country. And one of the biggest fears about the 13th Amendment was something called miscegenation. Miscegenation was now thought to be something that would come about because blacks and whites would be able to live together, and if they lived together, ultimately they would reproduce together, and that would be a terrible thing for the white race, many people thought. The Republicans, who wanted the 13th Amendment, they turned that argument on its head. They said, well, actually, white slave owners, they are involved in miscegenation now. They're sleeping with slaves all the time, and that is one of the problems we have. So if you're really against miscegenation, you should get rid of slavery. That was the argument they used. It probably wasn't that effective. One of the things one of the most important things I didn't say, and others will probably talk about later, is this. Lincoln was a product of growing up in Kentucky. He married a woman from a prominent Kentucky family that had owned slaves. He was somebody that really was not from a slave-owning family. In fact, his father was very much against slavery. But Lincoln was a product of Illinois and in the Midwest, and it was an area where he had I'd say a racist view to some extent. He made somewhat racist jokes, even when he was president, and slurs privately about blacks. He had a different view, and his view all along was the view that if you're going to eliminate slavery, which he eventually came around to, he evolved his thinking. It wasn't that he was against slavery all along. He eventually evolved towards being against slavery. His view as a young man, and even as President of the United States, was that slavery really should be eliminated, but in the end, blacks and whites wouldn't be able to live together. So he was a big supporter of something called colonization, which is a word meaning blacks should be asked, if not forced, to leave the country. And even as President of the United States, he spent an enormous amount of time trying to figure out how he could get money to colonize the blacks when they're freed, send them to Africa or to Central America or to Colombia. And only at the very end of his administration did he realize that wasn't going to work. But not until the 13th Amendment was passed did he stop talking about the idea of colonizing the African Americans. In fact, as a member of Congress, he was a member of Congress for two years, one term, he proposed legislation that didn't pass that said that slavery should be ended in the District of Columbia, provided it was done voluntarily, there was compensation for the slave owners, and the slaves were colonized. And that was a view that he had had all along, and actually many of the Founding Fathers had the view, and many people who actually supported the 13th Amendment had the view that blacks and whites could never live together. And in fact, many of the great abolitionists in our country, the most famous abolitionists, they thought slavery was immoral and should be gotten rid of. But many of them actually favored colonization as well. And many of them did not want blacks coming to the North and coming to the northern parts of the United States, and they were viewed taking jobs away from whites. So it wasn't as if people had the view that blacks and whites could live together. There were very, very few people in those days who thought that was going to be realistic.
It's important that you remind us that Lincoln's view of equality was not our own. In the Lincoln-Douglas debates, he emphasized civil equality for all people, but not social equality.
Yes. When you say all people are going to have certain rights, Lincoln looked at it this way. You have certain natural rights, the right to live, the right to be married, the right to have your children stay with you, the right to live a healthy life. But he didn't mean that you had the rights of a citizen. You didn't have the right to vote, to be in a jury, to have certain other kinds of civil rights. So Lincoln made that distinction, and many Founding Fathers did as well. So I think that Lincoln's view evolved over a period of time, but he would not have been somebody who would have said early on in his career, I want to end slavery because that's the morally right thing to do. He was against slavery, but he thought the Constitution trumped that moral view and ultimately didn't want to end slavery until later he realized it was the only way to save the Union.
So why did Lincoln change his mind about the scope of the 13th Amendment? An early draft he proposed would have compensated slave owners who freed their slaves but not abolished slavery everywhere in the Union. Why did he embrace the broader view?
Well, ultimately, he concluded that there wasn't enough support for compensation. It was going to be too expensive. He actually proposed at one point that Congress pass legislation that would provide about $400 million to compensate slave owners. Interestingly, there was no compensation for the slaves. It was only for the slave owners. Slaves weren't to be compensated. They were to be ultimately colonized. But Lincoln recognized there wasn't enough support for that, and ultimately he dropped that idea. Lincoln's view in the end was that the best way to end the war was the 13th Amendment, because if you had that amendment, the South would recognize that there was no way to come together and maintain slavery. In other words, people would say, after the Emancipation Proclamation was issued, Lincoln did have a solution to solve slavery in the states after the war was over, because the Emancipation Proclamation only dealt with the war period. After the war was over, it was Lincoln's view that the southern states could come back into the Union if 10% of the citizens would vote to be, in effect, loyal to the Union, and if they would eliminate slavery by state legislation. He wanted to do it through state legislation. In the end, that didn't get very far, and so he thought in the end the only way to convince the southern states that they could come back into the Union was to make it clear that the Constitution had been changed and it was out of his hands. And therefore, if you want to come back into the Union, you have to recognize that slavery's been eliminated.
How did Lincoln get southern states to vote for ratification? Georgia voted for it. I gather Andrew Johnson did some lobbying, but how did he pull it off, and how accurate was the Lincoln movie in describing who voted for it and who didn't?
Well, in the first question, remember, you had some people who were loyal to the North and the country who lived in these southern states. Not everybody was in favor of the Confederacy who lived in these states. And of course, it didn't take that many citizens to vote to create a new, in effect, government in a state. So you needed, only a few states did it, but you only needed about 10% of the citizens who had voted before in the 1860 election to vote to now be in favor of being loyal to the country. So it wasn't a gigantic percentage, and only a few states actually did it. The movie Lincoln is interesting. The book was written by Doris Kearns Goodwin, and all of you probably know that. She wrote a book that really emphasized how Lincoln had brought his cabinet together and other people who were really political opponents of his. Before she wrote it, she had talked to Steven Spielberg and said, "I'm writing a book about Lincoln," and he said, "Great, I want to option it." And he did. But the book wasn't completed until 10 years later. When the book was finished, it's about 600 some pages, a number of scriptwriters were given the task of writing a script for it. And they went through several scriptwriters because it's a comprehensive book about Lincoln, and it was hard to really figure out what to do. Ultimately, the final scriptwriter, a brilliant scriptwriter, came up with the idea of focusing on something that was only 5 pages in the book. Those 5 pages dealt with the 13th Amendment. The movie itself was ironic. It was well done, pretty historically accurate, but it was filmed, ironically, I've always thought, in the Virginia state capitol. So the capital that's the capital of the Confederacy was actually where they filmed it. And interestingly, if you look very carefully there, one of the sons of Virginia, a man who grew up in Virginia, wasn't often recognized as such, was Woodrow Wilson. If you look carefully at the movie, in the state capitol, there is a bust of Woodrow Wilson. Now, obviously, he hadn't been born yet. In terms of the vote, there was an inaccuracy in one respect. You may remember that when the votes are being called, they are called by state. And actually, votes are not called by state in the House. They were really called by individual names. But in the end, I think the movie is pretty historically accurate, and I think it does a great service to the country by explaining the 13th Amendment, its importance, and the celebration that came about after it was actually passed, though, it took about 9 months, or took about 11 months to ratify it.
You mentioned the celebration. Tell us more about the reaction to the amendment. How did the country receive it?
Well, it was received very well, certainly in the North, because it was seen by many people as the right thing to do morally. It was seen as economically the right thing to do as well for the South and for the North, because it was a fair way to treat people. But I can't say everybody in the South was jumping up and down for joy. But I do think that it did have the effect of ending the war relatively quickly thereafter. And it made it clear that the only way we could get the country together again was a union where there were no slaves. But again, as I try to say at the beginning, the 13th Amendment is an important amendment, maybe the most important. The 14th and 15th Amendments were important as well. But it's tragic that the Jim Crow laws and other laws really grew up that went around these amendments. In effect, we had another 100+ years where there was enormous discrimination. It wasn't called slavery. We had a number of things like poll taxes that weren't dealt with by the 14th and 15th Amendments. So we didn't solve all of our problems by a long shot with those amendments, but it was an important first step in beginning to correct these problems.
Well, in a moment, in the next panel, we're going to extend the story that you've set up so beautifully and talk about the relationship between the 13th, 14th, and 15th Amendment. But before we close, just a few more words, if you would, about these phenomenal documents. This one was sold at the Philadelphia Great Sanitary Fair. What was that, and how did how did this one emerge from that sanitary fair? It doesn't sound like a lot of fun.
Well, the Sanitary Commission were commissions like the Red Cross. They were designed to raise money for wounded veterans. And I think Lincoln signed, I believe it was 47 of them. And again, it was supposed to be sold for $10, and not that many sold. So ultimately they were, I guess, transferred around. And over the years, collectors of historic documents have bought these, and they cost more today than $10, I can assure you. But they are really good symbols. Now, what's the point of actually thinking about it? Why do I like to buy these documents and other kinds of documents, the Magna Carta or the Declaration of Independence? The point is not to say that I own them. I don't have anything in my house. Everything is displayed at a place where people can see it and think about it. And the important point is this. I think Americans need to know more about their history. We don't know as much about history as we really should. In a recent survey, when Americans were asked who was the first Secretary of Treasury, about 35% said Larry Summers, which is not true. Very good secretary, but not the first. About 30% of Americans in another survey by Pew, when they asked what river did George Washington cross during the Revolutionary War, said the Rhine River, which is not in our country. And in a survey of high school sophomores not long ago, more high school sophomores could name the first 3 names of the 3 Stooges than the first 3 names of any founding fathers. So my point is that I hope that when people see these documents, they go back and read more about American history. If you read more about history, you'll learn what mistakes we've made, maybe what mistakes we could avoid in the future, and you become better citizens. And just as Sandra Day O'Connor has devoted her post-Supreme Court years to civic education, I completely agree with her that we need to get civics back into our school system, into our education system, and that by having documents like these around where people can see them, they will go back and think more and read more about them. It's not the document that's important, it's really the thought process afterwards, so you can really think about why we had this document, why do we need this document, and how can we be better citizens now that we have a different kind of society, and how can we make our society better. That's why I try to buy these things and put them on display so people can really think more about our country and our good and bad things.
David, by loaning us this 13th Amendment, you have made it possible for citizens across the United States to see, and in this wonderful presentation, you've helped us understand its historic context. Please join me, ladies and gentlemen, in thanking David Rubenstein.
Thank you. Thank you.
Excellent. Really good job.
Shall I go this way?
Sure. That's great.
Thank you. Okay, so I'm...
Please come down here. Yes, we should all come out together. Ladies and gentlemen, it's now my great privilege to introduce a truly extraordinary panel of Reconstruction historians and jurists. I'm going to introduce them briefly, and then we're going to delve into our conversation. Sidney Blumenthal, my old friend and colleague at the New Republic many years ago. is a former assistant and senior advisor to President Bill Clinton, senior advisor to Hillary Rodham Clinton, and currently advisor to the Clinton Foundation. He's the author of, well, he's one of the most distinguished political journalists of his generation and has just done better historical writing than anyone of his generation. He's the author of several books. This year, A Self-Made Man will be released. This is his first book in a trilogy on Abraham Lincoln, and he is just riveting on the political context that shaped Lincoln and his thinking. Dr. Alan Guelzo is Henry R. Luce Professor of the Civil War Era and Director of Civil War Era Studies at Gettysburg College. The author of several books, including Abraham Lincoln, Redeemer President, which won the Lincoln Prize in 2000, Lincoln's Emancipation Proclamation, The End of Slavery in America, which won the Lincoln Prize for 2005, and Lincoln and Douglas, The Debates That Defined America, which won the Abraham Lincoln Institute Prize for 2008. His most recent book is Abraham Lincoln as a Man of Ideas. Dr. Lucas Morel is class of 1960 professor of ethics and politics and head of the politics department at Washington and Lee University. He is editor of Ralph Ellison and The Raft of Hope, a political companion to Invisible Man, the author of Lincoln's Sacred Effort, Defining Religion's Role in American Self-Government. He's just published an edited volume of scholarly essays called Lincoln and Liberty, Wisdom for the Ages. And another good friend of the National Constitution Center, Chief Judge Ted McKee, was sworn in as judge of the U.S. Court of Appeals for the Third Circuit in 1994. He has given most of his career to public service. He was an assistant U.S. attorney for the Eastern District of Columbia, a judge of the court details. Pennsylvania, D.C., exactly. Definitely in Pennsylvania. You don't want to make that mistake. A judge of the Court of Common Pleas, but the main thing that Ted has done is just been such an evangelist for constitutional education that he has spearheaded this incredible initiative we have here called Courts in the Community, where he and other judges of the Third Circuit are regularly coming to the Constitution Center to talk to school kids about what it is to apply the Constitution in their courtrooms. The kids are riveted. I hope the judges are enjoying it. And he is just a great friend of constitutional education. Ladies and gentlemen, please join me in welcoming these incredible panelists. We have a lot to talk about. I just want to set the stage by putting on the table a question that David Rubenstein raised at the end of his presentation, which is the relationship between the 13th, 14th, and 15th Amendments. So if I can do this in a paragraph, let me try to set it on the table and then ask you to tell me how I've done and to fill out the details. As I understand it, the 13th Amendment is passed, and some of its most enthusiastic proponents believe that it eliminates private badges of discrimination, such as the efforts by southern states to pass the so-called black codes, which denied the freed African Americans the right to make contracts, to sue and be sued, and so forth. But others disputed that broad ruling, and therefore Congress passed the Civil Rights Act of 1866, which prohibited this sort of discrimination and gave African Americans the same rights to sue and be sued, inherit property, and make contracts as white people. But President Andrew Johnson vetoed the act. It was passed over his veto, but some still questioned the constitutional authority of Congress to pass the Civil Rights Act. And therefore, the Reconstruction Republicans concluded that a new amendment was necessary, explicitly guaranteeing African Americans the same privileges and immunities of all citizens of the United States, as well as equal protection of the law, and giving Congress the power to enforce that article by appropriate legislation. So the 14th Amendment completely eliminated any doubts about Congress's constitutional authority to guarantee equal civil rights to African Americans. But as David also said, civil rights did not completely guarantee equality. They didn't include political rights like the right to vote, and the 14th Amendment explicitly was not intended to give African Americans the right to vote. It took the 15th Amendment, the final of our trilogy, to extend to African Americans the right to vote and to complete the effort that some thought that the 13th Amendment achieved. So, Alan Guelzo, how did I do? And what would you add? And more specifically, you're such an authority here. Do you want to tell us more about just the 13th, or begin by saying more about, I'm going to ask you about the relationship between the three documents.
I think what you've tried to do is to draw as straight a line as possible. Get from A to B, because that's logical and that's simple. In fact, it looks more like a zigzag. A step here, a step over here, a step over there, with the word oops occurring at several points in between. What I mean by that is this. The 13th Amendment abolishes slavery. Slavery as a legal institution disappears. It can't happen anywhere in America, therefore there can't be slaves. Well, there are now freed people. What is to be their fate? Is it to be left to the states to decide? Well, yes, because that was the way things had always been done. States were the entities that determined who voted, how often you could vote, who had certain civil privileges, who did not. And so you looked at a situation where suddenly, all right, we've abolished slavery, but who are the freed slaves? Are they citizens? The oops comes in because the Constitution didn't really have a definition of citizenship. The word citizen is mentioned several times in the Constitution, but there's no definition of it, either on the national level or on the state level. So the first response to the zigzag after the 13th Amendment is to say, ooh, we need to establish what a citizen of the United States is. And a citizen of the United States is very explicitly defined in the 14th Amendment. It's someone who is born here. They could have made it a matter of, well, you have to be born of United States citizen parents. They didn't do that. That would have been what they called the jus sanguinis. In other words, citizenship by blood. Instead, the rule that is laid down in the 14th Amendment is the jus solis. You're a citizen if you're born here. That would include all the slaves. That was a deliberate choice. So slaves are now citizens of the United States because now we know what a citizen of the United States is. But there's another zigzag. The zigzag is so many of the civil rights are determined by the states. There's no hard and fast rule about what civil privileges belong to citizens of the United States and what civil privileges belong to citizens of individual states. So the 15th Amendment is itself yet another move to straighten out this zigzag pattern by directly specifying that voting rights belong to national citizenship and therefore belong to all American citizens irrespective of color. Those three amendments, although when we put them in order, look like a straight line, really are moving back and forth, feeling the way. Because, you know, Jeffrey, no one at the end of the Civil War had a handbook on Reconstruction. I could not, if I had lived then, reach in, as we do with this wonderful book.
Nice.
There was no instruction book how to do a reconstruction, and there was no simple process of 1, 2, 3, 4, 5. They had to improvise, and they're constantly taking one step and realizing, oh, now what do we do about this next situation? And so the 13th, 14th, and 15th Amendments really are not that straight line, although I think in a way that's actually more of a compliment to them. Because what it says is these amendments were not just stale events like, oh, all right, well, let's have another amendment. Instead, they are real responses by people who were trying to understand the situation on the ground in the chaos of the post-war months.
Well, beautifully said. And you've taught us a whole bunch of things about the 14th Amendment, including we now understand the first sentence, and I'm going to quote from the text as much as possible. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That overturns the Dred Scott decision, which says that African Americans cannot be citizens of the United States, even if they are freedmen, and grants to all citizens full privileges and immunities. But you also tell us that there was disagreement about what those privileges and immunities were. We see from Section 2 of the 14th Amendment that they anticipated that southern states might deny African Americans the right to vote and would have a proportionate reduction in their representation in Congress, and that it took the 15th Amendment to guarantee full citizenship. So thank you for that. Lucas Morel, please do.
Lincoln gave a number of speeches and made a number of comments about what he preferred to call restoration as opposed to reconstruction. He didn't want to concede that anything was destroyed, that the states were not, there was no destruction that happened. But I think his best comment on Reconstruction, which explains the zigzag that Alan just pointed out, was his second inaugural address, which will be celebrating its sesquicentennial next month. Everybody remembers what line from the second inaugural address? With malice toward none, with charity for all. It's in the last paragraph. It's the first line. Actually, the last paragraph is its only line. But you don't get there without going through the most important paragraph, which is the third paragraph, which is the paragraph that talks about not just how devastating the war was. 4 years was long, much blood, much treasure. But slavery, white enslavement of blacks, white supremacy had been around for a lot longer. And Lincoln thought, as a people, even if we beat Johnny Reb in the battlefield, we still have the battle inside, right? Lincoln's might didn't make it right, as it were, in their minds. And so what Lincoln tried to spell out to the country on March 4th, 1865, when he ascended again to the presidency, was to say, we will not be able to move forward with Reconstruction, with restoring federal authority over the people of the United States, the practical relation of the states among themselves. We won't be able to move forward unless we have a common memory of what this war was about, why it happened, and what was the result, and emancipation being one of those results. Lincoln was pointing out that unless we saw the war as a judgment, yet nay, as a divine chastisement on the nation for what's been called a fatal flaw, right? The sin of slavery, a sin that dates not back to the Declaration, but to 1620. Until we understand and by that believe that slavery really was wrong, Reconstruction is going to be a very tall order to accomplish. So I think without that context, we can't understand any of the attempts to try to restore the federal authority.
That is riveting. I can't wait for the audience to read your work on religion and Reconstruction, and you're reminding us that for Lincoln this was not just a legal crusade, but a form of divine retribution and atonement is so important to understanding this context. Sid Blumenthal, your book is going to be a definitive reconstruction of the politics behind the 13th Amendment and Reconstruction. Give us some sense of the texture of what constrained Lincoln, what he was trying to achieve, and how he understood the 13th Amendment as it actually emerged.
The 13th Amendment emerges from a political campaign, the campaign of 1864, Lincoln's re-election campaign. By no means a certain thing. Lincoln, in fact, wrote a document that he sealed, glued, and had the members of the cabinet sign. They didn't know what was in it. And what had he written? He had written that he was going to lose the election and that he was going to do everything he could after losing the election to try and save the Union in the interim, when his opponent, who was not pledged to end slavery, but in fact had agreed to a platform that was against ending slavery, would be elected. So this was a near-run thing. This was by no means certain. And people underestimate the degree of opposition from the Democratic Party during that year in the North, not simply from the South and the Confederate armies, which were quite formidable, but from the Democratic Party in the North. Some of them were called Copperheads. They had taken the Liberty pennies as a sign. They had secret organizations, some of them, called Sons of Liberty. That document over there from the Philadelphia Sanitary Commission that he signed was at an event where Lincoln delivered a very interesting speech in which he contended with the idea of liberty, which we're still contending with today. We have people who call themselves libertarians. Lincoln said, what he was dealing with was the liberty of the wolf. And he was there to protect the sheep. And so that's a different concept of liberty. And Lincoln was, as we all know, a lawyer who liked argument. So Lincoln had a very difficult time getting through his election year. It required General Sherman and General Sheridan, and then he had political momentum, and it was on that political momentum that he decided that he would he would pursue enactment of the 13th Amendment. He was a politician to the marrow of his bones, and he did not want to waste that moment and wait for another possible moment when it could dissipate. And he did many things. He was people talk about the hidden hand presidency of Dwight Eisenhower. Lincoln, in many ways, was a hidden hand president. And he would do many things, some of which we don't even know about, to help move events. He was a kind of prime mover of politics. And I'll just say one of them. I don't want to speak too long. But when he had decided to move for the 13th Amendment, he arranged very quietly for the first African American to step on the floor of the House of Representatives and to address the House. Never happened before. It was a close friend of his. Very little of their conversations are known. He was Henry Highland Garnett, and he was probably closer to Lincoln than Frederick Douglass. He was a radical. He was a minister. He was a free black. And he had a congregation in Washington. He had been in New York. And his speech, which undoubtedly Lincoln discussed with him, includes many of the themes of his second inaugural and begins to raise the question of what emancipation means in terms of rights for the slaves. So Lincoln is acting in very subtle ways here.
Beautiful. That vivid example gives context to the comments that David and I were discussing about his less than progressive views on race, but you remind us that with this friendship, his actions in some ways belied that. Ted McKee, to what degree is the 13th Amendment relevant in jurisprudence today? We saw that the framers of it, some of them thought that it would eliminate all private discrimination. Is it cited in contemporary cases? And give us a sense of the contemporary jurisprudence of the 13th Amendment.
It's very rarely cited. It was cited recently. It was the basis of a decision by the Fifth Circuit last year, actually, which I can talk a little bit about if time permits. But if I can kind of tie the answer to that question into something that Lucas said about the second inaugural of Lincoln, because I think it gets at the heart of your question, and it gets at the heart of the vitality, and continued viability of the importance of the 13th Amendment, particularly Section 2. As you recall, Section 1 is the one which eliminates slavery. Section 2 then empowers Congress to pass all laws and enact all laws which are necessary and appropriate to that end. Soon after this happened, in 1883, there was a group of cases actually, that came before the Supreme Court called the civil rights cases. And they were brought out of something which sounds very common, public accommodations. It arose out of the Public Accommodations Bill of 1864 that Jeff mentioned earlier. It was an attempt to try to use the power of the second section of the 13th Amendment to open up certain areas, restaurants, inns, in Washington, D.C. and around the country, where blacks were prohibited from going, in large part based upon the mentality and the jurisprudence under the old black codes that were mentioned. An action was brought arguing that the provision of the 1864 Civil Rights Act meant that those private actions were no longer valid. And the key word there is private, because the 13th Amendment, unlike the 14th and 15th Amendment, reached private conduct. The 14th Amendment is limited to state action. 15th Amendment as you heard, is limited to state action. The 13th Amendment is not that restricted. It goes after private action. And it was hoped that these private black individuals could gain redress against private actors who were prohibiting them from going into restaurants and inns, things of that sort. The Supreme Court said something which is very important, and since then it's gotten kind of implanted and conflated into Section 2. It's not in Section 2. And that is the court recognized the authority of Congress in Section 2 to make all laws which are appropriate and necessary to eliminating slavery. But it went further and it said the badges and indicators of slavery, which is great. The problem was it then went on and looked at the public accommodations that were being denied access by the blacks and said, well, look, this is not a badge or an indicator of slavery. It defined slavery very narrowly. It said basically slavery is a relationship of power between a master and a slave. Indicative in that relationship is one of absolute power of life, death, corporal punishment. It means that blacks can't testify in court. They can't appear as witnesses in court. We're not talking about that here. We're just talking about whether or not a private individual has to open up his or her business to a black person. And that has nothing to do with slavery. And in a brilliant dissent, Justice Haney foreshadows a later case which overturned this, in which he said, you can't look at, and it goes back to the phrase that you referred to, the common memory and the common morality. You can't define slavery so narrowly that you wipe out of it the common memory of what it meant to be in a slave-master relationship. And these laws do nothing more than try to strike down the vestiges, the badges and indicators, if you will, of that master-slave relationship. Therefore, they're well within the scope of Congress's authority to legislate. Unfortunately, that was a dissent. It's so important today because you can ask, well, what are the badges and indicators of slavery? You could argue that it's racial profiling. The Fifth Circuit case that I mentioned earlier arose out of the Matthew Shepard hate crimes. People were prosecuted under the hate crime law that was enacted based upon Section 2. And there was an attack made on Congress's authority to enact that legislation. The Fifth Circuit upheld it. The problem is, I don't want to go too far with this, there was a case in 1968, Jones versus Moyer Company, where an action was brought to prevent somebody from not leasing property to a black person. It was brought under a federal law which made it illegal to refuse to rent or sell to someone based upon their race. The decision in that case is significant because it could have been rendered based solely on the Commerce Clause. The issue was the authority of Congress to reach into the relationship between a private landlord or seller and the purchaser. Easily could have been resolved on the Commerce Clause and said, well, look, it's clearly constitutional because Congress clearly has the authority to legislate laws under its Commerce Clause authority. So far as I can tell, there's only one mention of the Commerce Clause in that entire litigation, and that it occurs in an exchange between Justice Stewart and the attorney for the plaintiffs during oral argument. The whole case was litigated based upon Congress's authority under the Commerce Clause to prohibit leasing, to ban a practice which allowed people to lease to blacks. The Supreme Court decided that not on the Commerce Clause authority, but under Section 2 of the 13th Amendment. And it's a wonder that they did, because they said that this is nothing more than a badge or indicator of slavery, and clearly Congress has the right to reach it under Section 2 of the 13th Amendment. It gets a little more complicated because there are two more recent cases, City of Bourne and the Shelby County case, which you've probably heard of. But I'll kind of leave it there. Basically, it's relevant today because back in 1883, the Supreme Court said in the civil rights cases that Congress has the authority to define what is a badge or indicator of slavery. Now, if that is still a valid jurisprudential concept, it is absolutely huge. And I question how viable it is, but the language is still sitting there. It's still in a majority opinion, and that part of it has not been undermined. And it would give Congress the authority to go pretty far in terms of reaching things that Congress determined were badges or indicators of slavery. I said there are two intervening cases which make that a lot more difficult than I just made it sound.
Ladies and gentlemen, you've just heard a superb lesson in constitutional law, and I want you to go and follow up on the cases that the Chief Judge mentioned. He just told
us. Why are you doing it by this wonderful, this wonderful book? It's not in here, but
it's really amazing. Tragically, you can't find these cases in this document, but you can find them in the new, equally thrilling, interactive Constitution that the National Constitution Center is creating with this advisory board with the Federalist Society and the Constitution Society. And when we launch on Constitution Day next year, you'll be able to click on any provision of the Bill of Rights and original Constitution, see commentary on the leading cases written by the top scholars on both sides of the aisle, both what they agree about and what they disagree about. And we've just done a model where Rick Pildes and Brad Smith write about the 15th Amendment, and you'll see what they think is the settled law on the question, some of which the Chief Judge just mentioned, and then they'll have separate statements about open contemporary controversies. But I want to sum it up again quickly, because these are crucial points. Ted just told us that some of the framers thought that the 13th Amendment banned private discrimination as the badges and instruments of slavery. Congress relied on that in passing the Civil Rights Act of 1875. The Supreme Court struck down that act, arguably violating the original understanding of the framers of the 13th Amendment in the civil rights cases. And it took until the 1960s in that Jones case that he mentioned that you should go check out for the Supreme Court to actually uphold a ban on private discrimination under the 13th Amendment. There's one final wrinkle. We've just opened this great exhibit on Kennedy downstairs, which you can also go see after the show. The Kennedy administration, because of those civil rights cases that the Chief Judge mentioned, decided to rest the constitutionality of civil rights legislation on what he called was the Commerce Clause, on Congress's power to regulate interstate commerce. A sort of odd home for it, since the framers intended it to be rested in the 13th and 14th Amendment, but he's noting that there's some current cases that are going back to the original understanding.
The Commerce Clause is a safer way to, if you can build the record, you've got to build the record. In the hate crimes case, it's arguable whether or not the record could have been built, and that's why it's based upon Section 2 of the 13th Amendment, because how do you establish a record of the impact of hate crimes on commerce? You probably could do interstate commerce. You probably could do it, but it's a tall order.
Should someone devoted to the original understanding of the 13th and 14th Amendments rest congressional authority on those amendments rather than the Commerce Clause?
Well, again, the problem is City of Bourne, where the court basically imposed what's called the congruence and proportionality test on how far Congress can go in defining rights. That grew out of the Religious Restoration Act. And Congress had tried basically to turn back and cut back some of the Supreme Court's jurisprudence, which it was interpreted narrowed the rights of individuals to engage in religious practices. Congress was concerned about it. They enacted this act. And in there, the court, I think Justice Kennedy wrote the opinion, and he said that in order for Congress just can't create rights out of whole cloth. The rights that they create have to be based in congruence and proportionality to those rights which have their source in the Constitution. If you do that, since badges and indicators of slavery are not in Section 2, there's a problem. And given what the Supreme Court did with the Voting Rights Act lately, it seems to me to suggest, that's why I said Commerce Clause is safer, because the way the politics and the jurisprudence is going, I'm not sure how much traction one could get as an advocate in a court now, arguing Section 2's badges and indicators of slavery. It's a lot safer to base it on the Commerce Clause. That's very, very clear, at least I would have thought so, absent some of the diction in the Affordable Care Act case, but it's a whole different story.
Well, you see how incredibly relevant these amendments are to contemporary questions. In addition to sponsoring this very wonderful interactive Constitution, we're going to have a series of debates across the country for the next 5 years about these questions. We're going to present both sides and allow you, the people, to make up your own mind about what these amendments were originally intended to mean and what they mean today. We have time for brief closing thoughts from each of you, and I'm going to let you, that there are some great questions from the audience, but I think I'm going to, I'll pose this to you, Alan Guelzo, but also allow you to give more broadly your thoughts about what you want our audience to know about the 13th Amendment. The question is, how did the Freedmen's Bureau come about? Did it help blacks transition into mainstream life? Maybe you could tell us about the relationship between the Freedmen's Bureau and the 13th Amendment and what Lincoln was trying to achieve.
Freedmen's Bureau is a federal agency which was created in the spring of 1865 to, as the full title of the Bureau indicates, to resettle, administer property, reclaim unsettled lands, and, in a sense, provide a mechanism for assisting the newly freed slaves to move out of the environment that they had been in, which is the environment of slavery, into the environment of freedom and citizenship. There were many ways in which this could be done. One major way is, what about ownership of land? Here are former slaves. They're standing on land that they have farmed for years, in some cases for generations. Does that give them title to that land? Have they earned that? The Freedmen's Bureau has to determine that. Freedmen's Bureau is also going to be involved in litigation about exactly these civil rights issues on a one-by-one basis. And sometimes officers of the Freedmen's Bureau are going to be appearing in courts, and they're going to be making arguments this way. Yet, the Freedmen's Bureau was not really given very much in the way of budget, not much in the way of teeth, and not much in the way of staff. President Andrew Johnson grew to loathe the Freedmen's Bureau and did his very best to cripple it. And in fact, by 1871, the Freedmen's Bureau has, for all practical purposes, been dismantled. But while it was in operation, it was a potent force as a sort of midwife, bringing to birth an entirely new cohort of citizens for the United States. If it had been able to do more, go further, work faster, then perhaps the history of Reconstruction itself might have been very different. Certainly, the officer who was in overall charge of the Freedmen's Bureau, Oliver Otis Howard, former Major General in the Union Army, and a man of exactly the kind of devout faith and morality that Lucas was talking about as being part of Lincoln's ideal of what has to guide the country. And yet, Andrew Johnson, as a president, and the Democratic opposition that Sidney was talking about, really succeeded in emasculating the Freedmen's Bureau, and in the end, sinking it, so that what could have been a major transitional agency really is prevented from serving that purpose in American life.
Beautiful answer. Lucas Morel, was there any thought regarding colonization to send the freed slaves to other areas of the U.S. territories, similar to Andrew Jackson's movement of people to Oklahoma from North Carolina?
Not that I know of. Lincoln, there's two things to do with Lincoln and colonization. Yes, it's true, Lincoln was a long-standing proponent of colonization because he thought that whites would not be willing to free blacks and then coexist with the blacks. He thought it was the next best thing. There was no good solution that the majority white population of the United States, which is north and south of the Mason-Dixon line, was going to stomach in terms of emancipation. Emancipation was always a two-part question. It was never just, should we free the slaves? It was always, but what then? As Frederick Douglass would always say disparagingly, you know, the Negro problem. He says, this isn't a Negro problem. This is an American problem, right? We never say, what shall we do with the white people, right? But all the common problems are, what should we do with the Negro? You know what Douglass's answer was? Leave us alone. Your interference has been, your beneficence has been a positive injury to us. So short version is Lincoln was in favor of colonization as a palliative, as kind of the spoonful of sugar to help the medicine of emancipation go down. By the time of 1863, his secretaries, Nicolay and Hayes, say he sloughed off the idea. But one thing that modern scholars who are actually thinking that Lincoln was still in favor of it almost till the day he died overlook is that as early as 1854, in a very famous speech at Peoria, Illinois, Lincoln says out loud to his audience that even if his or our gut reaction is black colonization, a moment's thought on the subject, we would realize it would never work. He says that out loud, explicitly, as early as 1854, which leads me to believe his heart was not into colonization for the next 10 plus years. I've never heard of any proposal of Lincoln doing what Jefferson was proposing, kind of the diffusion thesis. It'll be easier to emancipate or encourage white owners to get rid of their black slaves if they aren't so densely populated, right? That was the big fear, was servile insurrection. The fear was if you if you not did it gradually, but if you had mass emancipation, what might be at the top of the to-do list for those freed slaves? Right? Go to Walmart? No. Pick up eggs on the way home? No. Kill Massa? Interestingly enough, though, what happened even to blacks who were enslaved throughout our history? They became Americans. He mentioned a book that I wrote on Ralph Ellison. Ralph Ellison taught us in his essays, in his novel, in his short stories, that blacks have been here for as long as there's been a here. And in the process, they became Americans in spite of the oppressive conditions. That meant culturally, religiously, politically. And so the great fear of mass Nat Turner's rebellions happening was never really, I think, in the offing. But it was a palpable fear to guys like Jefferson, to Henry Clay, even to Alexis de Tocqueville, the greatest foreign observer of the United States. He thought, he didn't predict a civil war, he predicted a southern war between blacks and whites. He never thought whites, as Lincoln put it, would be cutting each other's throats over the question of whether slavery should be the future in this country. So colonization for Lincoln, I think he never really had his heart in it. It was, as I said, just a way to try to help emancipation along. For him, Liberia was hopeless. It would have been something more like Central America. He thought, and it was very controversial, Frederick Douglass wasn't at this meeting, but he heard about it afterwards when he had what they called a Negro delegation to the White House, when Lincoln shared this idea of colonization in the very year that he was drafting the Emancipation Proclamation. He just said, look, even in the best place in this country, blacks are not treated legally, socially, or politically as the equal of whites. In short, saying to them, why would you want to live among a people who have been treating you like this? Can't you get the ball rolling for colonization? And he made sure that there was a reporter present. And if you read this account, it's probably, maybe along with some of the statements he made in the Lincoln-Douglas debates in 1858, probably the harshest things we hear from Lincoln directly to black people, the leaders of blacks at that time, about their existence in this country. And I think there's something else going on there. It would take a little more time to explain that, but I don't think we've gotten to the bottom of that very important meeting that Lincoln had with that black delegation.
Powerful stuff. Sid, this picks up on some of Lucas's really important observations. The question says, what were thoughts as to what slaves were now to do after they were freed? They had no jobs, nowhere to go, no way to support themselves. What were Lincoln's intentions about how they could achieve full equality?
That's an excellent question. At the end of the war, hundreds of thousands of slaves were wandering the country. Their social situations were uncertain. Some of them were looking for their families. The Freedmen's Bureau was a very important institution to try and deal with this question. Just to deal on two grounds. One, Lincoln had told James Blaine, who was a congressman from Maine, later a presidential candidate, that his idea was to operate point by point. It's in Blaine's memoir. That's how Lincoln operated, but it's not as if he didn't have a principle and an idea. It's stated, as David Rubenstein said, in his April 11th speech, his last speech, just days before his assassination, where he publicly speaks about opening citizenship to the slaves. Lincoln knew, Lincoln was more than canny, more than clever. He understood that this was going to lead to some form of citizenship, and he was going to have to do the politics of that. Perhaps his worst political decision that he ever made was to name Andrew Johnson as his vice president. And the reason he did that was, of course, for political reasons, to have a border state running mate, to help him in what they called the Union Party in 1864 in this difficult election. And Lincoln paid very little attention to his vice presidents. He didn't include them in his cabinet meetings, for example. His only meeting with Andrew Johnson as vice president was on the day of his assassination, when he told him basically to shut up. Don't give speeches. You're inciting all kinds of hatreds. You're a demagogue. Stop it. And I don't want to see you again. And that was their relationship. What would Lincoln have done? What would Lincoln have done? Well, we know who he surrounded himself with. There's some people who say he'd made an accommodation with the radical Republicans. Perhaps. James Speed, his Attorney General, who was the brother of his old best friend, said that. That's perhaps. Edwin Stanton was there, very devoted to the idea of a very tough Reconstruction. And Lincoln was very close to Stanton. Grant was there. Grant would do what Lincoln wanted. He would. And the U.S. Army was still out in the field. And he had other advisors, men like Howard, around, who could serve his purposes, his larger purposes. We don't know. He was assassinated. But what I feel is that what he would have done would have been not what Andrew Johnson did.
In fact, the worst that Lincoln would have done or might have done would have been better than the best that Andrew Johnson did.
Well put.
Said so well. And
it's all on the booklet. Right?
it's in the booklet, especially to the degree that the 14th and 15th Amendments are there in the booklet. And part of the reason they're there was that the Congress could not tolerate what Andrew Johnson was doing. And they felt it was required for them to create these amendments to deal with this president who was opposing them on every score in dealing with a positive Reconstruction, to the extent that he vetoed the admission of the state of Colorado because he thought that the state of Colorado would elect senators and representatives that would oppose what he was doing. So we had you had in Reconstruction the Lincoln's afterlife, which is the disintegration of his legacy, which leads us to 100 years afterwards, where we had to have a second Reconstruction.
So Ted McKee, Chief Judge McKee, last word to you. First of all, I've buried the lead. This is, ladies and gentlemen, Lincoln's birthday, on which we're launching this exciting initiative to celebrate and commemorate the 150th anniversary of the Reconstruction Amendments. My question to you is, 150 years later, has Lincoln's hope for equality that was embodied in the 13th Amendment been achieved in America? And as we sponsor this series of nonpartisan debates across the country, what are the topics that you think Americans should debate in order to educate themselves about the Reconstruction Amendments?
Well, the answer to the first question is clearly it hasn't, despite the fact, and I don't want to minimize the importance of Obama's election. It is mind-boggling to me. I'll never forget laying in bed and watching that, him and Michelle come out and trying to compose with it. Mind-boggling. It's huge. That being said, however, we clearly are not where I think back when the 13th Amendment was enacted, folks thought we would be 150 years. Later, as I was listening to this conversation, it sounds weird, but I was struck by that phrase that Stan Oliver used to say to Hardy, in Laurel and Hardy, for those of you who old enough to remember it, in talking about slavery, and that is, well, this is another fine mess you've gotten me into. Du Bois said at the end of the 20th century that the beginning of the 20th century, the problem of the 20th century would be the color line. I think even though we have a black president, the same statement can be made today. It's clearly there with what we have about the use of force and the society's response to the use of force in some instances, that the problem of the 21st century is still the problem of the color line. In terms of what people can do to educate themselves, I think if we could just start thinking sincerely in a non-defensive way about what are the badges and indicators of slavery. There's so much research out there now about subliminal bias and the mind bugs we all have, all of us, black and white alike, and how we tend to devalue not only black lives but black achievement and not see blacks as being able to succeed at the same level of whites. And it's there, it's planted in us from the day we're born, and as I said, it's planted in black brains the same way it's planted in white brains. To the extent we're going to get beyond that, one way may be to try to wrestle with how much of this baggage we're carrying on today is left over from the kinds of social dynamic, military and economic and political dynamic that we're talking about here in terms of Reconstruction and the three Civil War amendments.
Ladies and gentlemen, you've just heard a wonderful discussion about the contemporary and historic meaning of the Reconstruction amendments from our great panelists, from David Rubenstein, from Bro Adams, and from Justice O'Connor. But this is just the beginning. Please join the National Constitution Center and our great partners for the next 5 years as we engage all Americans in a debate about the meaning of these central amendments to the Constitution. You can participate in all sorts of ways by listening to podcasts, by looking at the documents here at the Constitution Center, by watching the debates that will take place here and across the country, but most important of all, by educating yourselves. All of us have an obligation to learn about the history and text and meaning of these amendments. You've just gotten a taste of the richness and complexity and importance of these amendments in American life, and I'm looking forward to joining you for many educational conversation in the years to come. Thank you so much, and now please join us for a reception outside. Many thanks.